Great, thank you. Ena mana, ena reo, ena whenua o te ao, no reira tēnā koutou katoa. I greet you firstly in Te Reo Māori, the language of the tangata whenua Indigenous people of Aotearoa, New Zealand, where I was fortunate to be resettled as a refugee and find a home free from persecution. And I acknowledge that today we are gathered here on the ancestral Lenape homelands and recognize the long-standing significance of these traditional lands for Lenape nations past and present. A warm welcome to you all to our panel today, Reimagining International Refugee Law, the Meaningful Participation of Refugees. My name is Rez Gardi. I am a Harvard Law graduate and an international human rights lawyer. My areas of focus have been international criminal law, human rights, and refugee law. And I'm the co-managing director of our seats, Refugees Seeking Equal Access at the Table. Through this work, I have increasingly seen that refugee law intersects with many different areas of international law, human rights law for sure, and many other aspects, but we're not still seeing the connection as strongly as we would expect. And importantly, through the work of our seat, seeing the increasing importance of law and policy working together and centering those policies on the experiences of people with lived experience of forced displacement. As a branch of international law, refugee law is often considered contentious as it intersects humanitarian needs, politicized security agendas, development goals, and overlapping jurisdictions and agendas. In parallel, over recent years, there has been significant process in furthering the ideal principle of meaningful refugee participation in policy-making spaces. The 2018 Global Compact on Refugees, the GCR, specifically calls for the participation of refugees in decision-making processes, with paragraph 34 stating that responses are most effective when they actively and meaningfully engage those that they're intended to protect and assist. Refugees themselves are an untapped experts and resource in international arenas that can have much to add to the international refugee law and policy making space. Adapting and developing these spaces offers new opportunity to imagine a future of refugee protection that is dynamic and effective, reimagining a future where refugee participation is harnessed as a supplementary mechanism for current international law practices, as a means for imagining a future that is more just, more legitimate, and more effective and people-centered. So to have these conversations, I have a brilliant lineup of panelists here with us today. So firstly, Ambassador Bob Rae, here to my left, who is a permanent representative of Canada to the United Nations in New York and has an impressive career spanning politics, spanning legal practice, and academia. Thank you so much, Ambassador Bob. And to my right here, we have Shahrzad Tadbakhsh, the Chief of Staff at the United Nations High Commissioner for Refugees. As a lawyer, she has extensive experience working on refugee protection. Next to Shahrzad, we have James Milner, Associate Professor of Political Science at Carleton University and Director of the Local Engagement Refugee Research Network, LEARN for short. He has been a researcher, practitioner, and policy advisor on issues relating to the global refugee regime. And last but certainly not least, we have Jane Mary Rwandwa, Executive Director of Dignity Kwanza in Tanzania. Her experience spans diverse areas, including refugee rights, nationality rights, migration and development, and NGO management. So it's my great pleasure to be able to moderate this panel today. So going right to the heart of the issue, 70 years on from the adoption of the 1951 Convention relating to the status of refugees, which is the main international treaty concerning refugee protection, it recently has been subject to diffuse criticism regarding its many related processes and on the adequacy given current political realities. Shahrzad, if I may turn to you, what is your sense of the relevance of the convention today, given the current status of the refugee system as a whole globally?
Thank you. Thank you very much, Rez, for having us here and for having thought through about this panel and ensuring that the whole issue of refugee law is actually injected into this weekend's discussions. We're very grateful to you for that. I think this is very valuable. So thank you. And thank you for having us here on the panel as well. I'm grateful actually for this question because unfortunately we hear it very often. The convention started negotiating 50, 51. Is it still relevant? And there are a lot of calls for it to look to see whether we actually need a whole new convention because, as you've said, developments that are sensed that are more political or the circumstances have changed in a manner that some have argued that the convention is no longer relevant today. Now, for us, and I think for all of the refugee experts, the 51 Convention really has been and continues to be very much the cornerstone of international refugee protection globally. And it has saved millions of lives throughout since it was adopted, especially, I have to say, in the larger developing states that are hosting the vast majority of the refugees, where 75% of the refugees are hosted. I mean, I don't want to be too provocative, but I always find it very interesting that criticism of the convention and its relevance today, we're actually not necessarily hearing that from the South, where it's mostly coming from states in the North, where in fact, there are the politics that come in and that they focus more on the lack of solutions because inevitably, and I acknowledge that, growing mixed flows that are coming to the borders and a lack of maybe capacity of effectively implementing the refugee definition and quickly being able to identify who is in need of protection, and importantly, also identify who might not be in need of protection and to enable them to be returned in dignity and safety back to their countries of origin. But because that's so challenging, again, I don't want to be disrespectful or in any way too provocative, but the easier route has been, oh, the convention is irrelevant and let's just, set it aside. And, our concern has always been not only is that not right because the convention remains very relevant, but realistically, we also know that if we were to ever go back to the drafting today, we would never get what we need when it comes to refugee protection. So if our hearts and minds are really in the place of wanting to sincerely say, look, is it relevant today because we're not able to effectively protect the people considering all the new violations that might be taking place? Well, we're only going to see the absolute opposite if we continue down this path of questioning the relevance of the 51 Convention. Now, that's more of the politics around an answer to that question. But, especially because we're here in a legal audience, I really want to stress that, in fact, legally, there is no need for a new refugee convention in that it still remains as relevant today as it was back in 1951. And let me explain why in a few minutes, if I may. It is really important to understand this concept that we often hear that the 51 Convention is quote unquote a living instrument. You all must have heard that throughout your engagement. And I have to say, there may be questions on, well, what does that exactly mean? Because we say it's a living instrument, meaning it's as relevant today as it was in 51, because it's a living instrument. From our perspective, we stand very strongly by that term. And the reason is because we insist that the 51 Convention actually has to be interpreted within a broader context of the larger international legal framework, including in particular the positively evolving human rights legal framework, as Rez said at the very outset. You have an evolving set of human rights framework that not only includes new instruments, as we are seeing new forms of violations coming around, but also we have a whole set of experts that are known as the treaty bodies that are attached to the different conventions and the covenants with the view of supporting their interpretations, with time that are backed by court decisions that use those new interpretations. And here, if I may, I wanted to give you a few examples of the evolving nature of human rights law that in turn feeds the interpretation of the refugee definition in the 51 Convention that enables us to be able to say the convention is a living instrument. So I'm going to start with a couple of examples specifically. I'll start with female genital mutilation. I mean, who would have thought that in 1951, someone would have said, someone who's fleeing from a situation of female genital mutilation because there's no protection from it from the state is either unable or unwilling to protect against female genital mutilation, and the person and the woman refuses to succumb to that. Do we need a new convention to extend protection to that person so they're not forced to go back to a situation where they would have to forcibly undergo female genital mutilation? Where you have treaty bodies, you have the Convention Against Torture and CEDAW, that through their general comments, which are interpretations that they give to the different articles in the convention, that have specifically identified and defined female genital mutilation as a form of torture under the Convention Against Torture. And it has specifically defined it as a harmful practice in the references in CEDAW. So when we look at that definition under human rights law, and you bring it into the living instrument of the 51 Convention and say, well, then persecution, it's not just about a simple form of torture that maybe one might have understood in 51, but human rights law has now defined torture to also mean forms of female genital mutilation. So by drawing on an evolving human rights framework, that helps us define later on in 1989, female genital mutilation as a form of torture, aka a form of persecution when a state is unable or unwilling to protect that person. It's an example of how the 51 Convention is a living instrument drawing on human rights documents. Same thing can be said about domestic violence. Equally, a number of treaty bodies, but in particular, again, CEDAW has found domestic violence as a form of gender-based violence. And again, when it gets so defined in the human rights bodies, it helps us then in turn define persecution in line with an expanded and a more relevant appreciation of what do we mean when we talk about persecution. So when a woman is unable to get protection from a state from cases of domestic violence, the treaty bodies have interpreted that as being a form of the gender-based violence against which the state is not granting protection. And so if and when that person crosses an international border and is able to really show that there's both in practice and in law, but in particular in practice, and a lack of protection from that state, then drawing on human rights bodies, persecution gets defined in a manner that recognizes that as a form of gender-based violence. Again, not something we would have necessarily thought about in 1951, but today the convention is properly and effectively interpreted in a manner that covers that. And I really want to maybe inject a thought here to say, this is not just UNHCR saying this, these are states, they're courts that have also so interpreted the convention and the different elements of the definition, drawing on human rights law in that context. Maybe a third example, LGBTIQ. Again, maybe back in 1951, one would have never thought about the need to extend protection, or that they never envisaged the 51 Convention as a convention that would have extended protection to people fleeing persecution on account of their sexual orientation. But again, I have to say that you have human rights treaty bodies that have over and over again confirmed that sexual orientation is innate, the dignity of the person, and that as such is a protected characteristic against which someone who's persecuted on account of it needs to be they need to be protected, and there can't be any kind of persecution or discrimination against that person on account of their sexual orientation. So drawing on the interpretation of an evolving human rights legal framework. We use that in further defining persecution and further defining membership in a particular social group, which is another element within the refugee definition. And then even, I'll go as far as even saying climate. Climate equally, we often think not covered under the 51 Convention, but when in reality, we know that more often than not, just to give you an example, often violence gets erupted where there are diminishing resources because of the impact of climate change. And when there's an underlying racial, for example, conflict that's ongoing, and there's diminishing resources, we have seen circumstances where because of someone's religion or because of someone's ethnicity, they are being discriminated against in terms of access to those limited resources, or they are even further persecuted as a result. And when those individuals flee across the border, and because of the mix, the nexus between conflict and between climate change, the 51 Convention does cover them and does extend protection in that. So like I said, it's not just UNHCR. These are court decisions time after time that have drawn on the human rights legal framework in giving interpretation to the 51 Convention, different elements of it. But in all humility, if I may also say, yes, court decisions have made these interpretations. But I'll even go as far as saying, even if they hadn't, the 51 Convention has an article in it, Article 35, that gives the supervisory responsibility to UNHCR. It is our mandated obligation and responsibility to guide states in the interpretation of the different elements of the 51 Convention. So as the experts and the mandated agency to help states in interpreting the convention, it's also our responsibility to keep ourselves well informed on the evolution of all of the international legal frameworks and ensure that the 51 Convention is interpreted in a manner that is alive and relevant in today's circumstances so that it can continue saving lives in the same way that it has saved lives over all of these decades for millions of individuals. I should maybe, if I may add one last word, of course, that we won't have time to get into, but I spoke about nexus and climate and conflict, but we can't also ignore the regional instruments that also exist and that equally go in and to add to the sort of toolbox of international protection and that have equally been developed over time that enables the convention to remain alive and for the people to get the protection that they need. And add to the regional instruments, there's not just only law, there's also a growing set of practices and policy developments that are also happening. And I just want to maybe put in a plug, if I may, in particular on the Global Compact on Refugees, which was adopted in 2018 and where it really aims at giving a little bit more of policy direction around the concept of international global responsibility sharing. And there you see that there's equally a whole new body of areas that might not necessarily in the letter of the convention be written, but that in line with its spirit, if not also its preface actually, makes references to elements that can be further developed through negotiated texts or drafted texts such as the Global Compact on Refugees and commitments that flow from that, like the Global Refugee Forum that takes place every 4 years to put the GCR into practice. So there are lots of things that could also be said around policy that gets developed beyond the actual legal development that keeps the convention alive. Including aspects around meaningful refugee participation, Rez, that you mentioned, but I'll stop for now on this. Thanks.
Thank you, Shahrazad. I think that sets us up very well for a strong understanding of the convention and the way that it can be used to protect refugees fleeing persecution. And you mentioned the regional framework, which I think would be really interesting to explore a little bit further if we go to Jane Mary. Working in Tanzania, I believe you would be very familiar with the regional elements of refugee law and mechanisms such as the OAU Convention governing the specific aspects of refugee problems in Africa. So practically speaking, how does the 1951 Convention serve as a tool in the work that you do relative to these regional frameworks as well?
Thank you, Rez. Thank you so much for inviting me, for giving me this opportunity to speak about our work. First of all, I would like to talk about, to speak about the legal framework in Tanzania, how we interact with international law. So we are a dualist state. So after signing and ratifying international law, we have to legislate a domestic law that would incorporate the provisions. So our interaction is mostly with that domestic law. So the way we look at international law on the ground is in three ways. One, whether the international law itself is comprehensive. I think that has been spoken very well. The second issue we look at is whether the national law that is adopted meet the standards of the international law. And third is whether now the practice on the ground is at par with the law, international and domestic law. So Dignity Kwanza's work is to bridge the practice and the law, but also to advocate where we see gaps in the laws, in the national law, where we see gap between the national law and the international law. And as a legal and advocacy organization in Tanzania, most part of our work has been advocacy. And this is, our advocacy work focuses on changing or reshaping the narrative, refugee narrative, because through the years we have been engaged on the ground, we realize that the practice will never come at par with the law if the narrative about refugee is what it is right now. So we are focusing on advocacy, and also our refugee protection in the country has been so much influenced by many years before by moral it has been looked at as a moral obligation rather than a legal obligation. Yeah, the way refugees were received and protected in Tanzania, we had legal framework that was not necessarily so good, but the treatment was totally the opposite. So that sort of engraved the idea that refugee protection is just a moral obligation. So our work, our advocacy work, apart from focusing on reshaping the refugee narrative, we also work towards attaining a healthy balance between looking at a refugee protection as a moral obligation as well as a legal obligation. Why are we talking about a health balance? As we are, where we are right now, our law still has some gaps. And so we're looking at, there are times where insisting on implementing the law as it is might not get us where we are. For example, our national law now doesn't talk at all about refugee participation. But if you come back to look at, if you talk about moral obligation, yeah, we have received these people as refugees, but there are people who are capable of saying what is good for them. You know, they have urgency and all that. So just make that, we make that argument. So that's another advocacy point from our end. We have also learned that apart from focusing on the narrative, we also learned that there's a specific area of there's a gap between the understanding or perception about refugees between the people who are living with refugees, the host community members who are interacting with refugees on day-to-day basis. Their perception is totally different from the policymakers. So people who are employed and sent to areas where refugees are living. So their understanding of refugees is different. So our advocacy work is also trying to bridge that understanding because it's not true that everyone in Tanzania. Oh, I'm sorry. Is that better? Yeah. So our advocacy work is also geared towards bridging that gap between the understanding at the lower level, at the grassroots level of the people who live with refugees vis-a-vis the understanding of policymakers. So we're using different approaches. One of the approaches that we're using is to keep dialogue about refugees alive. So this is one thing that we are trying to promote locally, because it's for many years refugee protection has been a subject of specialized people, the Ministry of Home Affairs, UNHCR, and some few humanitarian agencies in that field. And although that has been has had its advantages, it has had its disadvantages as well. So refugee issues are under the Ministry of Home Affairs, that is charged with security. And the impact is that now refugees is viewed from the security lens only. So one of the approaches is to keep the dialogue open, but dialogue bringing in multi-stakeholders actors, so that we get different perspectives of different aspects that goes into refugee protection. And through that, we're also bringing in other actors as well, trying to encourage them, educate them about refugees, for them to mainstream refugee issues in their day-to-day work. So, for example, we're bringing in women rights organizations, for example, and children rights organizations, and we talk to them about refugees, so that whenever they are, because these are some of the agendas that are sort of national agendas and less contentious than refugees. So for them to know, when we talk about women's rights, we should also remember refugees. In Tanzania, refugees are hosted in refugee camps. And if you're not in the humanitarian space, that means you don't know what is happening in refugee camps. So trying to bring in all these actors and say, you're talking about women, there are women refugees, this number of women refugees in refugee camps. So that's another area. Refugee participation, I think I talked about it. We're trying to promote refugee participation. Currently, we're not, the law doesn't say anything about refugee participation, and the practice, this is where one of those areas where we reference to the law is made, that the law doesn't say anything about that. But in all these engagements that we're having, be it with government officials, be with other actors, media, we always make sure that people with living experiences are part of those discussions. But even further than that, we're also engaging with the registrar of NGOs, for example, to see what are the barriers for registering refugee-led organizations, and what can be done so that refugee-led organizations can be recognized and be registered in the countries. So I can leave it there, and yeah, thank you.
Thank you very much. And turning to you, Ambassador, considering your work in Myanmar, especially on the Rohingya refugee crisis, you'd know firsthand the different challenges and differences present when working in countries that have ratified the 1951 convention and are party to the convention, and working in situations where the convention has not been ratified. Could you speak a little about your experiences working on that particular area?
Sure. Thank you very much. It's a pleasure to be here, and I just would say to everyone that if you think you're busy now as refugee lawyers, you ain't seen nothing yet, because this is going to be the next 40 to 50 years are going to be a period of unparalleled population movement around the world. Displacement and mobility, which is a fact of life, but more than just mobility, displacement, forcible displacement, depopulation of rural areas, younger populations on the move, looking for work, looking for jobs, looking for opportunity, climate change forcing even more movement, I think we all need to really embrace the importance of what you do and what we're doing. Look, these are critical issues when we look at what does the future look like. The future is going to be very busy in this area because it is a critical area for human rights. It's a critical area for social justice, and it's a critical area for the economic and social development. So it's going to be very much with us. Just to remind you, the Rohingya population lives in northwestern Burma, Myanmar. There is, as I discovered when I became the special envoy for Canada and started boning up on my imperial history and other forms of history, just a brief description. The Rohingya are Muslims who probably, and here I'm entering into very controversial territory, history is vitally contested, and history is all critically important to understand what is the condition and what is the situation affecting the Rohingya. From the perspective of the Burmese population in Myanmar, the Bama population in Myanmar, the perception is that the Rohingya are outsiders who came to Myanmar from Bengal, from India. That in the time of the empire, as some of you may know, the British Empire, there was no border between Myanmar and India. It was one. And the fact that there's no border meant that populations moved. And many of you will also know from your knowledge of history that when empires are created, they move populations around all the time. And so when I worked in Sri Lanka on the conflict there, Tamils were moved by the British to work in the tea plantations in Sri Lanka in the middle of the 19th century. If you look at what's happened in Fiji over the years, you'll understand that indentured Indian population was moved from there to work in the sugar plantations in Fiji. So the forced movement of population was carried out as a feature of imperial policy. The Rohingya version of their history is a little different from this perspective. And their vision, the version of history is to say, look, we have always been, or for as far back as we can tell, we have always been part of this part of the world called Rakhine, which is now in the northwest part of Myanmar. So from their perspective, they say we are native to this land. We're not foreigners, we're not strangers, we're not outsiders, we're insiders. But this question of who is an insider and who is an outsider, who is a migrant and who is a citizen, is a critical political and legal and social question. Mm-hmm. So when the British left and when the border was redrawn, the motto of the Bamar movement, which was led by Aung San Suu Kyi's father, Aung San, was Burma for the Burmese. To outsiders, this meant, oh, well, it's a nationalist movement. The Burmese want to take over. And so we'll leave, we're gone. So the British left. I'm simplifying history in a rather dramatic, almost cartoonish way. But there's lots to read on this subject, by the way. But from the point of view of those who are living in the territory of Myanmar, in the territory of what was either called Burma or Myanmar, depending on your political perspective, Burma for the Burmese meant, it meant Burma for the 45% of the population who are Bamar. And it was a chance for the Bamar to say to the British, you're gone, and to say to the ethnic populations, including the Rohingya, you're out of luck, guys. You've no longer got an imperial protector or imperial presence that's moving you around on the chessboard. We're in charge. It's our country. And herein lies the lesson and the challenge of what is at stake here. So for the Bangladeshis, their view is the Rohingya are not refugees. The Rohingya do not belong to Bengal, Bangladesh being the successor state to Eastern Bengal. The Rohingya are alien to us. And the Myanmar and Burma population says, no, they are alien to us too. So it's a genuine tragedy in terms of why people are stateless, how people are stateless, and what then happens. Just to put this in policy terms as well as in legal terms, what we know now about the successful, most successful policies towards refugees is actually to allow people to work and get educated as quickly as possible. Where that is done, the gap between the domestic population and the refugee population is limited. People are allowed to engage. There's more of a breakdown between the two populations. Where that doesn't happen for a variety of political reasons, you have a real challenge. And we have a challenge right now in the case of the Rohingya population in Bangladesh, which is very serious. The challenge is this. The Bangladeshis say we don't want to create conditions in the camp which make people feel that they're being encouraged to stay. And in my first conversation with Aung San Suu Kyi, she said, Mr. Ray, you don't know anything about this. I said, thank you, I'll learn very quickly, don't worry, I'm going to become a student of this. She said, what you need to understand is we don't want the conditions in the camp to be a pull. And I said, well, I've actually just come from the camp, and it's not the Holiday Inn. There's not a pull factor that's going to be demonstrable. But she insisted that that was the factor. From the perspective of the Bangladeshi leadership, they say, we don't want the Rohingya to think that they are Bangladeshis, and we don't want them to be citizens, and we don't consider them to be refugees. We consider them to be migrants, and in fact, we consider them to be unlawful migrants who we are allowing to stay here as a matter of policy and as a matter of generosity. So the challenge for policy is huge. And the question really is, how do we respond in a creative way to deal with the fact that because of the civil war now in Myanmar, it's very difficult for people to be returned safely. It's very difficult to say you will be treated with dignity and respect and safety, and you will be in a position to be protected. So we're just going to send you back, refoulement, as we say. Well, where we are now is Bangladesh, to be fair, has said we're not expelling anyone, but we are, in fact, trying to offer people a chance to move to another place away from Cox's Bazar, which is the main site of the refugee camp, to another island off the coast called Basanchar. Not to go into too much detail, I would just say that we've seen some progress in education. The Myanmar curriculum is available to refugees in Bangladesh. We've seen modest responses on training and education, but we've also seen steps backward in terms of access to work, access to jobs, creation of a market, places where people can actually work and live. And when that happens, we get into a very difficult discussion about the view that's expressed often by the host country to say this population is a burden upon us. It's a burden upon the land, and it's a burden upon our people. And so you create distrust and you create social stratification. And you, to put it even stronger, you create hatred. And no one can read the history of the Rohingya genocide inside Myanmar without understanding that the mobilization of hatred was a very significant part of the displacement of the Rohingya. Facebook was the vehicle, and it was had dramatic impact on the Rohingya people as they were forced to move and forced to leave. So without the protection and the obligations that come to the host country, evolving successfully to deal with the needed changes in policy, we look at I was talking about what the future is going to look like. Potentially, we're looking at a future which is pretty bleak for people. Thanks to social media, I hear from people in the camp all the time in Cox's Bazar. Every day I'll have an email or a message or Facebook or an Instagram describing the conditions, sending me pictures, showing me what's going on. And it's very challenging for people. It's heartbreaking, frankly, and really, really hard. And just to end on a somber note, my first meeting in the camp, there was one particular person who was talking very directly to me, and I went over to see him and said, I'm about to go back to Canada, and I have to tell people what's going on. What should I tell them? And he pulled me in close and he said, tell them we're human. And that touched me very much when he said that. And I said, of course. And he looked at me, he says, no, you don't understand. You need to understand. They don't think we're human. And I can tell you that if you get a cab ride in Yangon, people regard the Rohingya as the lowest of the low. And when you hear somebody say, they don't think we're human, you have to reach out and cry and say, how can we do this to other people because of who they are, because of their social class or strata or race or religion or ethnicity or anything else. And this is the challenge that we face. This is the real challenge we face, is how can we stop the victimization of people who are being displaced and who are being forced to move? And how can we create a world where they're not treated in this way? And I think it's a critically important issue for our time, and I firmly believe that it's going to be one of the great public policy and international policy debates in the years to come. It's a huge challenge for us to figure out how to deal with this.
Thank you, Ambassador, for sharing all your experiences with the Rohingya crisis as Special Envoy for Canada. And something you said ended on of how do we stop victimizing people who've been displaced? And taking us back to the theme of this panel is the importance of agency of refugees, agency of forcibly displaced people. They know the challenges directly that they're facing. And most often they're on the front lines working hand in hand with their communities, coming up with solutions to the challenges they're facing. And they have a lot of expertise and lived experience that they can contribute to the way that we can implement these laws and policies. So on paper, we've got some great laws. We've heard about all the different ways that the Refugee Convention can be used in a very strong way to protect refugees and the importance of these documents, legal instruments that we have. So it's not a matter of new laws, but how are we implementing them and where are refugees centered within these laws and policies that we see. And so in thinking about this, I want to go to our token non-lawyer on this panel. We always need a political scientist to contribute to the conversation. If I can go to you, James, about where do the politics of the global refugee regime and the emerging norm of meaningful refugee participation practices influence some of these outcomes of what we've been talking about, these international legal processes and instruments?
Yeah, no, thank you, Rez. And it's great to be here. And I think the argument that I want to make flows very well from what we've heard before, global context of Tanzania, the plight of the Rohingya, is a very simple argument, is that the power of international refugee law instruments will best be realized if we engage with the politics of the global refugee regime, if we engage with the political context, the political structures within which these instruments are deployed. Like so many areas of international law, there's very few enforcement mechanisms for the principles of international refugee law. That on the one hand, as far as I've mentioned, that the preamble of the 1951 Convention says that the issue of refugees is one that's beyond the scope of any one country to address on their own, and is therefore an issue that requires international cooperation. And we've seen more than 30 UN General Assembly resolutions that have reinforced this principle of the need for international cooperation. But in the absence of binding commitments to share the costs associated with the granting of asylum, to cooperate, to ensure protection and to find solutions for refugees, we find these perennial gaps in the functioning of the regime itself. Not only the principles of the regime, but the ability of the core institution of the regime, UNHCR, to fulfill its mandate of ensuring protection and finding solutions. And it's interesting that when then High Commissioner Antonio Guterres, now Secretary General, in his last address to the Executive Committee, his parting wish list was, if there was one more thing I would have, it would be an additional protocol that makes cooperation binding. But of course, that's the holy grail that we won't realize, because it's states themselves that would need to commit to additional obligations, these additional binding obligations. So what we're left with is the ability to engage with politics. We're left with the moral and expert authority of UNHCR, its supervisory responsibility, to cajole states, to try and convince states to follow its lead in the progressive interpretation of international refugee law. But there are fewer carrots and there are even fewer sticks. So the question is, what does that leave us with? It leaves us with a very political global regime, as we have in very many global regimes, where states are able to pursue their interests, as we heard in the context of states in various situations, context of the Rohingya, context of Tanzania, and it's the more powerful states in the international system that are able, through the financial contributions that they do make, other policy instruments that they have, to pursue this policy paradigm of the containment of refugees within the global south. It's not by accident that 75% of the world's refugees are in the global south. And through this prevailing policy paradigm, we see these gaps in protection that have been described before, but also gaps in finding solutions. The average duration of a refugee situation today is more than 20 years. That's a regime that is struggling to fulfill its mandate, and this has raised questions about gaps, not in the meaning or the relevance of the instruments, but in the question of the ability to implement these principles, to make them real, to make them accountable, to make them predictable, and to make them effective. And for many, what happened in 2015, when the European Union itself was unable to cooperate in response to a mere 1 million people arriving in search of protection, that was a watershed moment. That if in a political community like the European Union, cooperation was not possible, how could cooperation happen at a global level? But 2015 was also the source of, or the instigator of a process that leads us with new tools and new spaces and new opportunities, as Shahrazad mentioned. That the collective realization, and here I really congratulate UNHCR in the moment that happened in 2015 to say, this is not just a phenomenon in Europe, it's a global question of how we reinvigorate this principle of cooperation. And so the Secretary General's report in 2016, leading to the New York Declaration, starting this process of leading towards a global compact for refugees affirmed by the UN General Assembly in December 2018, was a moment for a collective engagement in thinking about what are new norms, what are new standards, what are new principles, what are new standards of appropriate behavior by which we can ensure that we do better in these commitments of ensuring protection and finding solutions. And what was critical within those moments was the role of refugees themselves. And this goes to a point that you mentioned, Rez, of refugees engaging in this process of developing new global standards, not as passive victims, but as active agents. that many of the Syrians who had been displaced themselves had worked with UNHCR in the Syria operation, had understood not only the elements, the instruments of refugee law, but understood the politics of environments like Geneva and how to be able to make claims and to advocate within that space. And the result of what we have, as Rez mentioned, is in the Global Compact on Refugees, is paragraph 34 that sets a new standard of saying that responses are more effective when they meaningfully engage with those they're intended to protect and assist. But here's what's critical. What has happened since that moment in 2018 is that this has not just been an ethically desirable form of practice. It is a practice that has been reinforced in particular spaces of the global governance of the refugee regime, that through the accumulation of practice has demonstrated the substantive value of this emerging norm. That refugees participating in global policy processes contribute not just through their lived experience and through being able to share their experience, but through their expertise, through a perspective on the process of implementing policy that can really only come from those who are within that process itself. And so the discussion of building new policies, how UNHCR now benefits from a refugee advisory group to be able to bring perspectives on what would be the implications of implementing this policy in context X or Y, that brings substantive value to the meaning of the progressive evolution of the refugee regime. In the global governance of refugee resettlement, the Refugee Advisory Group has been able to realize new opportunities for solutions for refugees, fulfilling one of the core obligations of the regime itself. So the point that I would make is that this evolving norm, this emerging norm of meaningful refugee participation has the opportunity to address some of these political impasses that we've seen in the functioning of the regime. That through the development of mechanisms where refugee participation can be substantial, can be sustained over time, but not just appearing at a moment when the policy is adopted, but in helping to set the agenda. At a global level, that has resulted in policies that refugees themselves see as being more legitimate and more accountable, and ultimately will then participate in their implementation. But also in national contexts, from Kenya to Colombia, we find examples that where refugees substantively engage in the design, the implementation, and the evaluation of policies that affect them, the outcomes are more effective. And so where we face the question of how to make these enduring principles of refugee law more relevant, to have greater impact, what we see from the record of evidence over just a few years' time, this evolving norm of meaningful refugee participation holds great promise, just as we have seen in the governance of other areas of the UN system. In the governance of the rights of indigenous peoples, the engagement of indigenous peoples organizations and their representatives in decisions that affect them, in the engagement of persons with disabilities and ensuring the rights of persons with disabilities globally. That mantra of nothing about us without us is not just an ethical rallying cry, it's a means to make the regime itself more effective, more accountable, more legitimate, and ultimately deliver on its mandate of protection and solutions. Thank you.
Thank you. And I note, in the interest of time, maybe we open up the floor for Q&A. I've got lots more questions, but I think I see.
Speaking of nothing about us without us, I think we should include them in the conversation.
Exactly, Ambassador. So I saw a hand go up here first, and then there. Hopefully we have time, so over to you.
Thank you, and I have so many questions, but of course, in the interest of time, I'll try to have a very specific question for any of the panelists. I definitely think that international collaboration is going to be necessary, especially in a future where, unfortunately, as the ambassador said, is going to be very busy. And I agree, and I definitely feel the power of the 1951 Convention, and I love the language of particular social group to give ambiguities the future, as you mentioned. My concern, and maybe this is a very pessimistic concern, especially talking to asylum seekers about additional traumas that they've experienced as far as climate change goes. And my fear is, what do we do when we are seeing masses of populations come and there doesn't appear the nexus? You know, people have fled and they're seeking asylum, and the principles of not sending people back to a bad situation. What do we do in cases where there is no country left? The seas have overtaken land, or maybe the entire region has become a desert. Yeah. And in the interest of people in their own lives, they flee. But again, there isn't necessarily a targeting of a characteristic, rather it's just the consequence of climate change has happened. But yet we cannot, there is no capacity to return or relocate. And I think my personal opinion is we should have frameworks in place before bad things happen, in an interest of collaborating. Is there, what do you think about that? Do you still think that there's good tools in place, or do we really need to get going, start coming up with new frameworks to address new futures?
Well, if I could just add two thoughts. One is between 1938, which was the year of the Evian Conference, and 1951 was only 13 years. But something rather dramatic happened in between, the Holocaust and World War II. So it shouldn't take a Holocaust and a World War for us to realize that the policy frames we have today are completely inadequate. And the second point I would make is that mobility and migration are good things, not bad things. They're not a sign of breakdown. They're a sign of human agency. We've talked a lot about refugee agency, but mobility is generally a sign of agency. And so what we have to fight against is the politics of protectionism and the politics of nationalism and the politics of racism that exists in so many economies and so many parts of the world that restricts and prevents people from migrating with relative facility between one place and another place. Our populations in most of the advanced economies are aging, and we need people. And yet we have created policies which restrict a lot the mobility of people and the movement of people. And that's a big policy shift that has to happen, and it will be a legal shift as well. So I would just say I don't believe for an instant that we have the national policy frameworks that will in fact allow us to respond adequately to the challenges. And just one last point, it's not just about saying, oh, we'll take more people. It's about where are you going to house them? How are you going to train them? How are you going to encourage their active participation and engagement in the life of their new country? How is all that going to happen? And it's going to require a commitment to say we're going to house people and we're going to bring people in. And in fact, it's going to be good for everybody if we do that. It'll be a positive thing. But we've got ourselves now in a headspace, and it's not just in the advanced economies. It's, I mean, the notion of local nationalism and various forms of, social stratification are a factor in every form of politics around the world. And we need to take that on head on in order to embrace what it means to be living in more open societies, which is what's required. And that, I think, is the kind of political debate that we need to be constantly having, instead of fearing the other, fearing the arrival of the stranger, fearing the presence of people who are different than we are around us all the time. So that's what's needed, as well as the international changes. But it's a question of national policies changing as well, because that's where the core focus of each country has its own way of dealing with it, and we need to recognize that that's going to change too.
Okay, we'll go there. Yeah.
Thank you so much.
creating these spaces for
Yeah.
that type of participation. And recently we've seen Poland swiftly create this emergency NGO response to get Ukrainians housed and into school and working almost at an unprecedented level. So I was wondering if you could briefly speak to the role of NGOs and other non-state actors to facilitate this type of participation.
Bring the mic close. Just pick it up.
Very close.
That's it. There you go.
Yeah. Can you hear me? Yeah. So as I was speaking before, NGOs play a critical role in ensuring that refugee participation is a reality. As I was sharing, in Tanzania, there is no such thing at the moment. But under our localization work, we are promoting localization, but we make sure that we're talking about refugee participation as well. So our localization is not focusing on only local organizations. We're claiming space for local organizations as the first and last responders, but as well, we are claiming space for people with lived experience, because when we stand as local organizations, we talk about all this contextual knowledge that we have. We have been there when refugees are coming, we'll be there when refugees are leaving. But when we talk about people with lived experience, refugees themselves, we're saying they know better than us, and they are better placed to speak about themselves than us. So we cannot talk about localization if you're not talking about refugee participation. And that is why I said before, we are promoting that. We are in discussion with the government, trying to create space for them. So it's, I feel like it's an important role that we have, a local organization, to speak for refugee participation, because we really cannot do everything that refugees themselves can do. We can just do to a certain level. We can do advocacy, yes, but then when we do advocacy, when we have meetings and refugees are in the room and they share their own experiences, we see that it's totally different from when I stand and talk about refugees. So we have we have an important role in that, and we have embraced it, at least in my organization.
Thank you very much, Jane Mary. And also to add to that, I think it's important to carve out a particular role for refugee-led organizations and critically refugee experts themselves. So to mention a little bit about the work of our seat, we work in particular countries right now to develop mechanisms for refugee advisory bodies to be set up that can work directly with governments, UNHCR, and other civil society actors as experts on the topic. So it's people with lived experience of forced displacement, but thematic expertise, whether it be legal protection, gender, LGBTQI+, resettlement, complementary pathways. So people are bringing lived experience as well as expertise to the table and working directly through these mechanisms with their government, states, and UNHCR to advise on policies, to advise on solutions. We've recently developed the United States Refugee Advisory Board right here. We've helped establish the New Zealand Refugee Advisory Panel, the Australian Refugee Advisory Panel, and now working actively in countries like Kenya, Colombia, Mexico, Malaysia, Uganda, to develop similar mechanisms that will have people with lived expertise and experience working directly with their governments. And so I think the more we see these institutionalized practices set up that creates a sustainable and ongoing channel, the more we see the impact between lived experience and working directly at the policy level, so they're not ad hoc approaches, but rather embedded in the process. So every time there's a consideration in place when it comes to policies that affect the lives of refugees, you can say these are the refugees that are directly working on this topic, and their voices are included, and they're helping to shape the way that the policies are designed, implemented, and then also the way that they're evaluated and monitored as well to see the effectiveness of them. So I think it's critical to move from this idea or principle of meaningful refugee participation to an embedded practice and doing it throughout everything you do, because it actually leads to better results, not just because it's a nice thing to do, but because you need to do it. Lots. We had this gentleman here.
And I just want to say, the ambassador's comments struck me as to the importance of a 14th Amendment that makes everyone born in the United States a citizen, this notion of birthright citizen, just so how critical that is. And we have to do everything possible to prevent any future administration from really trying to end that, or at least limit it, which is to do. I would like to ask you, in the United States today, white Americans realize that they will be in the minority in a decade or so. And the question of race, I think, is at the foundation of the anti-immigrant, anti-refugee animus. I wonder if you have any solutions, any ways to reduce this apprehension. And I wonder if I could ask Shazad one other point, and that is, I think the UNHCR has been a tremendous advocate for refugees and great knowledge of states compliant. There's one policy that bothers me, and that is the safe third country agreements that the United States has entered into, and even the Biden administration has essentially picked up on Trump administration policy. Singapore's not, but nonetheless, that is an active policy. Not to mention, UK is trying to do that with African countries. Likewise, the European Union has used government that actually safer countries in Italy are aware of it. Essentially, a refugee comes to the United States from Honduras, and if they have not applied for refugee status in Guatemala, they can be actually deported. In fact, if any country is willing to take them, they have to go back and could have to leave. I think that the thing that I want to bring to your attention, though, is that the UNHCR has really essentially approved of this policy. And even though you've tried to attach conditions, but it just disturbs me that I think, given the extensive use of this by kind of offshoring refugees to particularly developing countries, I think the UNHCR has to do really much more to condemn this practice.
If I could just make a point, and I'm not being facetious, I would encourage intermarriage on a massive scale. Seriously, I really think we have to accept the fact that this will be the culmination of what dealing with racism really means. Just breaking down the barriers between people, and recognizing that that's something that we have to continue to see as a positive thing. Because I think that we are the more we encourage, or the more we allow for passive forms of segregation, the more we're just reinforcing the differences that shouldn't be reinforced. And so I'm not being facetious when I say that. I think it's a wonderful thing that I see in my own country. The transformation of the country is in good part because people are mixing it up, and that's a good thing, not a bad thing. But I'll let Shahrzad deal with the difficult question of substance.
I thought you had the difficult question, which I am fully in favor of. As an Iranian who married an Arab, I think that I'm playing my part in this. And kids who have no idea where they come from as a result. Exactly. So they always say they're citizens of the world, so it's perfect. If I can just add one element to that perfect answer, if I may, it really is also that I think we have a responsibility as voters to try to ensure that we don't get to the stage that you're describing, because it is really also about fueling of hatred, if I may really say it in that context, but also a fueling of fear of the other that we need to overcome. Because, is that for me? No.
In your dreams.
A woman can only dream. Anyway, so on this, very quickly on the safe third countries aspect, if I may, with all due respect, to really say that it's not quite right, firstly, the definition and the description that you've given to a safe third country concept. What it means from UNHCR's perspective, and as we've advocated very strongly with member states, a country is only considered safe not because it has ratified the 51 Convention. that's not a safe third country. It's safe if it accepts to take the person back, or that it accepts the person. It gives them access to fair procedures. And all of these words, they're loaded, right? So I'm saying it quickly, fair procedures, but that gets broken down. And what does it mean that an asylum system is fair? And on top of that, that the person, once they're granted refugee status, they are able to exercise all the rights in the 51 Convention. So it is very expansive on what it means a country to be a safe third country. And we have spoken up very strongly against efforts, for example, of the UK to send refugees and asylum seekers to Rwanda. We could not have spoken up more strongly against those types of arrangements, because those are not safe third country arrangements. But I do have to say that as a matter of concepts and principle, these are not just sort of like, what did you say, like little attached conditions that don't have meaning. But if the conditions are met, it could also be seen as a form of responsibility sharing. I take the Central Mediterranean as an example. Is it fair to ask all of the countries at the border, Italy, for example, to be the one to disembark and receive and keep absolutely everyone? Or is it fair to say, look, we will do a responsibility sharing across all of the EU, where we will identify other European states that are considered safe in line with the serious conditions that have been laid out within the EU, and we will do a type of a responsibility sharing so that we can ensure that people are safely disembarked and that they are given access to asylum procedures, that their lives are saved, that NGO boats aren't floating around the Mediterranean for weeks on end with politics debating where and whether they should be disembarked. So it is, as a matter of principle, it can be a positive form amongst, for example, in the context of EU, and it's done in the context of Schengen, of responsibility sharing, but it is not a safe third country concept where it is a form of externalization, which is what the UK is doing when it wants to send back, or frankly, if I may say, some of the other countries that simply imply that because they're passing through a convention state, that is a safe third country. We've also spoken up quite strongly against that as well.
Anything? I think we can take one last question. Go ahead, please. That's another question for you.
I'll walk in where angels fear to tread and let the angels correct me. First of all, I got into a lot of trouble. I get in trouble all the time, but I got into a lot of trouble when I was drafting my report on the Rohingya and I did another report for our government on humanitarian and refugee issues more broadly, and saying that, the distinction between an internally displaced person and a refugee is not as big as you might think it is. And those who've been involved in this field for a long time said, you can't, there's a refugee is one thing, and another kind of displaced person is a completely different thing. I think what's happening now is, and I take no credit for this, I think what's happening now is there is now a focus on this question, the broader question of mobility and displacement. And that, I think, is something in policy terms which the international community is more engaged in. The Secretary General has given the responsibility to one of the Assistant Secretary Generals, Robert Piper, to write a report, to give us a study on what is happening, what are best practices, how can governments respond, how do we engage countries in understanding that this is happening in their country, that this is not something that can be avoided, and that it's a significant factor in the creation of conditions of conflict and of increased poverty, and those people who are placed in camps and are not able to work, are seen as outsiders, even for people who are coming in from another part of the country to where they're being displaced. So the issue of displacement broadly and the issue of internal displacement is a big issue. But it is subject to different the legal framework is different. And one of the things I think will evolve is a much broader policy response at the international level from within the United Nations community, from the UNDP and others who are involved in these issues, and saying this is something we have to address more broadly. And I think that's going to be an important political and social and legal question as we go forward. But you're right to address it, to see it as something which is specifically extremely important. And now I'll shut up, and Jane, now you can tell me how I need to be correct. Yeah, she's going to do. You watch her. She's going to do.
Yeah, it's a difficult question. In Africa, we have a Kampala Convention trying to address that. Many countries, mine including, are still not settled with who is a displaced person, internal displaced person, and who is a refugee, and whether to and how to deal with those people. So it's a challenging question, legally speaking, especially because the internally displaced person has not is still under the sort of protection of their own country, and so the intervention of the international community is sort of looking at all the needs around refugees that cannot be met, focusing on internal displaced persons can be a challenge, because at least those people are still within their countries of nationality. So it's a for me, legally speaking, I think it's still very complicated question. But as Bob has said, it's a question that somehow we need to find an answer to. So Africa, we have tried. The Kampala Convention is one of attempts to try to set legal standards on how to deal with those people. How much that is implemented on the ground or being enforced, that's another question. Thanks.
I'll just offer a two-line codicil on what's been said. This is a perfect example of where meaningful participation can be substantively useful. Those who are displaced navigate these categories every day. And so far be it for me to give an answer on how those categories perform. To be able to substantively engage, meaningfully engage, and engage in a sustained way with those who navigate these legal categories every day, that's where we're going to learn the most important lessons. So I just leave it with that. Thank you.
Thank you all. And I think that brings us to a close. I think what's been clear throughout the panel is that we're reaching unprecedented numbers of displacement. The accelerating climate crisis is only adding to the complexity, the scope, and the scale of refugee and forced displacement around the world. And we have strong laws in place, we have strong frameworks in place. So what's really important is coming together and taking an all of society approach and centering refugee voices in the solutions and implementing the laws that we have that are continuously evolving and provide ample opportunity for us to use to protect those in need, but ensuring that the policy and the politics also meets the standards that we expect for protection. And so drawing to a close, I would like to thank all of our panelists for your tremendous contributions and sharing your expertise and experience with us today. And I'm aware that I have a magic word that people are looking for, the CLE code. The code is monkey for those looking for it. So thank you all for your attention here today. And thank you to our panelists.
nice meeting you.
That's fantastic.